Scholarship Highlight, brought to you by the Center for Firearms Law at Duke University School of Law. This series is a part of the Center's broader effort to deepen the scholarly discussion of firearms law by engaging directly with some of the many scholars who are producing innovative and insightful work. I'm Jake Charles, Executive Director of the Center, and this week we're joined by Lars Noah, Chesterfield Smith Eminent Scholar and Professor of Law at the University of Florida. We're going to be talking with him about his article, Time to Bite the Bullet, How an Emboldened FDA Could Take Aim at the Firearms Industry, forthcoming in the Connecticut Law Review. Thanks for being here, Lars.
Thank you so much for including me in your series. It's very generous. And by the way, when I started this project back in May, I was able to tap into your center's online resources, lists of articles and so forth. So that was very helpful.
Great, thanks for saying that. So first off, can you just give us in a nutshell kind of what the article is about?
Okay, I suppose by now it's commonplace, at least in some quarters, to think about gun violence from a public health perspective. Now, what does that mean exactly? It's more than simply recounting the increasingly sort of depressing statistical information that is certainly out there in this area. Public health law is a fundamentally sort of pragmatic field. So it's much more about imagining solutions, population-based, prevention-oriented fixes for a problem that is affecting the community at large. And I was struck, I suppose, there were some commentators, not from the law side, but the public health literature, who kept invoking the motor vehicle safety history in this country. In fact, one of them, and I forget who it was, had this funny remark, imagine that General Motors and the other big automakers back in the 60s had popularized a motto along the lines of, cars don't kill people, drivers kill people. Where would we be today? And there is a genuine insight there, because if all we did with regard to motor vehicles focused on licensing of users, suspending licenses of irresponsible users, enforcing traffic regulations, so a very state and local kind of response, we would have missed out on an opportunity to design into the motor vehicle fleet some available safety features. Now, part of this is to invoke the success of the National Highway Traffic Safety Administration, a creature of the late 60s that was very involved at the federal level in terms of driving performance standards. It's also in part, I suppose, a reflection of changes in tort law at that same time, the increasing recognition of the crashworthiness doctrine, so that nowadays we have vehicles that have all sorts of additional features built into them so that we are better able, and some of these just strike me as magical, the things that tell you when you're drifting out of your lane and so forth. But simple things like seat belts, more complex safety features like airbags, bumpers, and the like. So the point is that there is an opportunity to try to anticipate hazards associated with products at the federal or at the supply level, not so much focusing on the user, the demand, or the retail level. Now, NHTSA, that's the federal agency charged with this area, obviously has nothing to say about guns. So I noticed that these same commentators would invariably invoke the Consumer Product Safety Commission as a possibility. And that's strange for a couple of reasons. As an administrative law person looking into this field, the CPSC is one of the more ineffectual agencies in the federal firmament. NHTSA doesn't come across looking all that better. So administrative law types regard the National Highway Traffic Safety Administration as something of a disappointment. So it was striking to me that the public health community would look at those as potential solutions with regard to gun violence. Now, the one agency, though, that they did not look at is the one that I'm most familiar with. I've been a student of the Food and Drug Administration now for 30 years or so. And I thought to myself, here might be an avenue for thinking about a federal, a uniform sort of approach to regulating consumer products in ways of accomplishing various forms of risk reduction. And I'll just give you the sort of the statutory hook, and then we can sort of unravel that as we chat. The FDA regulates since 1938 a category of products referred to as devices. Devices are defined in the statute as, among other things, items that are intended to affect the structure or any function of the body of man or other animals, and do so without depending on metabolism or chemical action on or in the body. Okay, that's a bit of a mouthful, but the sort of the focus or the question, if you will, is this something that affects the structure or function of the body? At a very sort of simple level, you would say that firearms, ammunition plainly do so. Now, most people would not make that leap because in common parlance, devices regulated by the FDA are medical devices. But it turns out that the category is not so restricted, that there are, in fact, a number of non-medical devices that the FDA has successfully asserted jurisdiction over. In some cases, it has done so unsuccessfully. And as the paper reveals, in fact, this is my starting point, it's tobacco all over again. The FDA 25 years ago decided to call cigarettes and other tobacco products devices. They were very serious about pursuing this initiative. They got buy-in at the White House. President Clinton was very much in favor of this. It wasn't until you got it into the federal courts that the effort collapsed. Though, as I point out in the paper, they may have lost the battle, but won the war, because ultimately Congress decided, you know what, maybe we should give the FDA specialized authorities with regard to tobacco products. So the effort was worthwhile, even if in the sort of the immediate period, it seemed to fall flat. And so what I try to do in the paper is imagine a similar sort of initiative with regard to the firearms industry.
Yeah, so one thing that I found interesting that you do is kind of play this is a serious argument that could actually get somewhere, but also even if it fails, it's going to be, it might do the same thing that tobacco did and get this on the national scene and get conversations going. So when you were thinking about developing this argument, which primary audience did you have in mind? The policymakers who might get this going, or scholarship, or courts? Like, what was your primary audience?
Well, you have to remember when I was writing this, over the summer. And in some sense, this was an effort to imagine life after the Trump administration. So I was sort of pegging my hopes on a certain outcome in the election. Had it gone otherwise, this really would be little more than more sort of academic navel gazing, if you will, or maybe a harebrained hypothetical. I do imagine that this is an effort to encourage policymakers, regulatory officials, to think about whether or not they could handle this in a sensible way, using already existing authorities. So in fact, 1 week after the election, the Washington Post had outed members of the transition teams for the different cabinet level departments. And I found the email for one of the people on the HHS team, that's Health and Human Services. And I sent this guy my paper. Also with the suggestion that maybe if this were something that appealed to them, that it would influence what type of person to seek out for commissioner of the Food and Drug Administration. I mean, we've had clinicians, practicing physicians, we've had clinical researchers, we've had healthcare economists. We haven't had all that many sort of core public health focused individuals in that position. And I thought to myself, much like David Kessler famously did as commissioner during the early Clinton administration, that this could be a legacy project for a new commissioner. There are minefields, to be sure, and we'll get into some of these. But what a neat thing to leave behind. So that's the way I sort of pitched it. I sensed that I got the brush off. They sent me a link inviting me to apply, which they maybe misunderstood that I was angling for the position, which I'm absolutely not. Instead, I thought, this is something that they might want to give serious attention to. But I'm not, I'm not giving up hope yet. Once there is a commissioner who's been nominated, I'm quite sure that I will share this piece with him or her. When the leadership at the FDA, new leadership is put in place, I will file a citizen petition attaching the paper. I did that a couple of years ago with a different paper, sent it to the FDA as a citizen petition, never heard back from them. So, I'd like to believe that this could have some real world impact, but I'm also, I think, ultimately realistic that no one is likely to sort of take up the challenge, partly because these officials, they are, in a position where they have to make certain choices. Where do you expend your political capital? You have scarce resources. Surely the FDA has plenty of important things on its plate at the moment. So you might hesitate to sort of reach out into a brand new area that is bound to attract all sorts of flack from lobbying groups, also the citizenry that's going to react badly to this sort of initiative. So I don't, in fact, imagine that this is coming down the pike in a couple of years and then watch as the courts decide whether or not it's plausible. But I sort of put myself in the position of, let's be naive, let's dream, let's imagine a way of doing this. And that's the paper that I produced. So we'll see.
Yeah. I mean, it's good goal for all legal scholarship to have some real world impact.
Well, and I must say, in reading deeply to learn about your field, which I knew nothing about before I started this project, there was, who was it? Ian Ayres and Fred Vars. They've been pitching very recently this fascinating idea of inviting people. It's sort of a Ulysses contract, I suppose. You waive your Second Amendment rights by getting your name added to the background checklist. And if you want to take it off, there's a waiting period, a cooling off period. That's a fascinating idea. I get the impression that they are, in fact, successfully pitching it to state legislatures.
Yeah.
That's dynamite. I mean, it's also fascinating as an academic exercise, but there's no reason why we can't try to be, influential outside of our sort of narrow domain. So at some level, I was hoping, and it's certainly not written for judges. It's written for regulatory officials, almost daring them to try to tackle this problem.
Yeah. So one of the before we get into some of the obstacles to the proposal, one of the things you talk about in the article is the ways that Congress has specifically taken away either public regulatory authority, so with ATF and the consumer. I always get this one wrong. The CBS,
Product Safety Commission.
Product Safety Commission, yes. And then private regulatory authority through civil lawsuits. So can you talk a little bit about some of those major ways that Congress has taken guns off the table?
Well, I mean, it's good that you mentioned ATF. There is an agency that Congress has set up to deal with And it's not just firearms, right? It's the merchants of death. It's the triumvirate of industries that are thought to be most dangerous in society. And yet it hamstrung that agency in various ways. It has limited the authorities granted to it. It has, sent fairly clear signals with regard to resources, budgeting, and so forth. There are various amendments scattered over the years, and in some ways, this was the hardest part of the paper, to do a concise sort of, what's happened in the last century with regard to legislative efforts. Things like not sharing trace data, or for the FBI with regard to background checks, you've got to destroy them after 24 hours. There's the, there are the riders that have been enacted in this area that strip not just ATF, but also the CDC, right? The Centers for Disease Control and Prevention, of trying to discourage them from sticking their nose in this area. NIH was added to the so-called Dickey Amendment roughly 15 years ago. So both of those public health service agencies have gotten the message to steer clear. Now, of late, the last couple of years, I think there's been some language in reports that accompany the Dickey Amendment that are designed to make clear this was only to protect against the expenditure of allocated resources for lobbying, if you will. It's not about doing basic research in the area. So there's been a bit of a thaw on that one. The National Park Service got the message, you can't keep people from bringing guns onto that type of federal land. Amtrak was singled out. The EPA was told you can't use TSCA to regulate firearms or ammunition. So there's a litany of congressional, almost shots across the bow, saying, stay out of this. And as you mentioned, 15 years ago now, you had Congress trying to make most tort litigation unavailable. So again, if you contrast this to what we have with automobile safety, where we have, it's not a big agency, but it's an agency that's been given fairly sweeping authorities by Congress, trusted to exercise its expertise, and you have fairly good sort of tort litigation available. That has affected motor vehicle safety in productive fashion. Whereas on the gun side, you've got an agency, ATF, that is fairly weak by design, and you have other agencies that might sort of take up the mantle. And I said before, public health is a pragmatic science. Well, CDC, NIH, those are public health agencies, okay? And Congress said, we don't want you messing with this. Fascinating to me, Congress has never warned off the FDA.
Yeah.
Now, the FDA has never suggested that it would enter this field. It could, though. And if you look back historically, the sort of critical authorization of device authority for the FDA, 1938, 1976, happened to coincide with fairly important legislation on the firearms side. So it would have been a simple matter for Congress to include what's sometimes called a zipper clause, to say we do not mean to authorize you to intrude in this adjacent area, but it never did anything of the sort. So to my mind, that leaves the area open to possible regulatory initiative to take, unilaterally intrude in the area. It may not last long, right? But at this point, at least, the opportunity exists. And by the way, the FDA, it's also not a terribly big agency. It's not even 3 times the size of ATF, but it has a tradition. It's sort of a can-do spirit, or some would say it's got a whole lot of chutzpah. This is an agency that views, it's better to ask for forgiveness, or it's easier to ask for forgiveness than to first get permission. They live by that motto. So they're perpetually doing novel things, and more often than not, the courts will allow it, and or sometimes Congress will say, you know what, yeah, we think this is a great idea, so let's give you the authority to do what you've already decided to do. So it's an agency that has a very different culture. And that's why, to my mind, it would not be completely unexpected, given what they tried to do with tobacco in the mid-1990s, for a sort of a crusading new commissioner at the agency to decide, this is a public health hazard, and we do have the tools to try to manage it. It may only have sort of an incremental effect at the end of the day, but ATF is asleep at the wheel, so let's do something about it.
Yeah, so that brings me then to, you talk about some of the obstacles to an FDA decision like this. Some of them are political, and one thing that I hear often when the comparison is made to tobacco is that with tobacco, you had changing customs and norms away from tobacco use being a generally positive thing, and maybe we have the opposite in the direction of firearms. And so what kind of political landmines are there? And then you also talk about the legal obstacles. So, Supreme Court decisions that talk about FDA authority for, I guess, major questions. So if you could talk about some of the political and legal hurdles.
First off, I'm not sure that the description of that tobacco was already fading from the scene. I was there, I got a front row seat to what was happening. I wrote a number of papers, railing against the FDA initiative. I thought they were out of their mind. And as I suggest in this paper, part of what was so useful about, in retrospect, the FDA's failed effort was that they, more than anyone else, I think, at the time, changed the conversation. That it became more acceptable to push back against the industry, that legislators were perhaps less beholden to big tobacco than they had been up to that point. So I give Kessler credit, the commissioner of the FDA at the time, for making this a signature initiative and causing people to think hard, I think, about whether or not this is an industry that should be left alone. Because up to that point, it was ATF with a little assist from the Federal Trade Commission and the Federal Communications Commission with regard to advertising, but there was very little federal control over tobacco products. So could we imagine that the agency could dial it back with regard to the way we think about firearms? Now, I suppose it depends on how it's pitched. With tobacco, it wasn't a frontal assault on cigarettes. It was instead focused on underage use and efforts to promote an addictive product to unlawful users. So it was very much about an attack on Joe Camel before your time. But so the agency was able to craft its initiative in a way that it was hard to be opposed to, I suppose. Now, could one do the same thing with regard to my suggestion? And I haven't really fleshed that out, but might there be ways of sort of taking a limited sliver of the problem, using the device authority to target that problem in a way that would minimize the pushback the agency would get from the legislative branch and the judiciary, and of course the industry. And once they've, gotten their foot in the door, then further down the road, maybe they can become more aggressive. But you're right. I mean, it's a different sort of problem. And one of the things I concede, it's first of all, tobacco is still a much larger public health menace than firearms violence. Okay. I mean, both are problematic, but tobacco is still in a class by itself. The other thing is tobacco products are invariably risky and have third-party effects, whereas, defenders of this industry, the firearms industry, would say it's primarily irresponsible users. So that there's not anything invariably hazardous about widespread availability of firearms. It's just when they're put to inappropriate applications, if you will. So yes, I concede that there are different challenges in that respect. Now, the political obstacles will start there. First of all, and people, although after what's happened in the last several months, nobody believes this anymore, I suppose. But for a long time, people were under the impression that the FDA was what is known as an independent agency. They are not. It is a unit of the Department of Health and Human Services, which is squarely within the executive branch, subject to close political control by the White House. And that's been made, very clear in the last several months. So it would still have to make sure that the White House and the Secretary of Health and Human Services, so if we're talking practical application, Xavier Becerra, are they on board? And Becerra, having spent a long time in Congress, may well be sufficiently attuned to the dangers to not be supportive of a move like this. Biden also, now President Biden, or incoming President Biden, he has a record with regard to firearms. He chaired a task force during the Obama administration on the subject. He was involved as a senator with regard to the assault weapons ban, the Brady Act, and so forth. So it's possible that the hires up that control what the FDA does might allow the agency to go off on this crusade. But then the question is, how would Congress react? Okay. And this is important because Congress has specialized tools that people in the administrative law community have long known about. This has been around since 1996. It's the Congressional Review Act. It allows for a rapid review of major rules and an override. So it facilitates fast legislative consideration of likely to be controversial rules. In fact, that's the fate that befell one of the Obama administration's firearms initiatives. The Social Security Administration was going to share records of disability benefit applicants that were indicative of mental illness with the National Instant Background Check, criminal background check system. And Congress, with a new sheriff in town, decided we're not going to allow that. And Trump signed off on that. Now, that's partly a matter of timing. If the Obama administration had done that maybe 2 or 3 years earlier, Congress would have overturned it, but Obama presumably would have vetoed it. And then you'd have to ask the question, do we have 2/3 majorities in both chambers to override that veto? So if an initiative like this were pursued early enough in a presidential administration with White House buy-in, it could survive that kind of congressional check. You could also imagine riders, okay, appropriations riders that Congress has used several times in the firearms context that would make it more difficult, I suppose, for a supportive White House to veto. So that's another risk, if you will, or pothole along the way. Uh, but neither of those, at least the way things have worked out. And by the way, when I wrote this paper, I was assuming that both chambers of Congress would be more friendly to the left. That obviously has not happened. So the prediction, although the prediction with regard to who's in the White House came true, the prediction with regard to the first branch of government, not so much. So it looks a lot harder than it did before. But to me, the biggest obstacle is the third branch, right? That the federal judiciary, given the membership that we see throughout the federal judiciary now, especially on the highest court in the land, makes me suspect that this would never, at the end of the day, survive. Which is, again, not necessarily a reason for not doing it. And things can change, right? 3 or 4 years from now, if this percolates up to the US Supreme Court, who knows? We might have different membership there. But as things stand right now, you would have to think, even if some FDA device controls might sneak by Heller, it's hard to imagine that the Supreme Court, as presently configured, would tolerate it.
So we've got a few minutes left, so I'll just ask one final question, and maybe can you talk about what you might envision an FDA doing with the things in its toolkit that would survive or could survive maybe constitutional scrutiny, and that might actually have an impact on gun deaths and gun suicide?
I struggled with that. I mean, what's the wish list? And I sprinkle various ideas throughout the paper. I mean, one thing I suggest, you could follow the lead of Massachusetts, which used 25 years ago even vaguer statutory authority to impose some serious controls at the manufacturing level. So whether it's things like magazine safety disconnects or load indicators or better trigger locks, materials used for cheap handguns, drop tests, performance standards, things like that, even safe use instructions, I think Massachusetts has tried. California has done some interesting things. I haven't really kept up on this one, but there was this idea of micro stamping bullets as they're discharged in assistance of, sort of criminal justice tracing of crimes or criminal use of guns. New Jersey tried, and I don't know that much has happened, something with regard to what's often referred to as smart guns, biometric features built in. At one level, I think that the FDA could usefully just, gather information that right now ATF has a really hard time accumulating and sharing the information and, keeping track of different models and their uses. And also, one thing that intrigued me as I worked through the project, this idea of bullet control. Instead of gun control, let's focus on ammunition. Guns are durable products, even more durable than automobiles are. You have cars that may be 20 years old that don't have airbags, obviously. Guns can last even longer than that. And it's going to take forever if we only now start modifying design expectations with regard to firearms for that to sort of affect in a meaningful way the marketplace. But you could do things with regard to ammunition that would have a much quicker impact. And I talk, for example, about exotic ammunition, black talon and so forth. I talk also about mundane ammunition, lead content in the public health community, that's a red flag. So let's get the lead out. And while we're getting the lead out, maybe we could actually come up with non-standardized caliber sizes as a way of restricting the usefulness of existing stocks of, let's say, high caliber, high muzzle velocity, or high energy sort of ammunition, large capacity magazines, assault rifles. I mean, those have been tried. Some states are still doing those. The federal government gave up on that after a 10-year effort. So you could, once you assert device jurisdiction, it would give the FDA the power to almost freeze existing technology and start moving it or pushing it into less hazardous directions. It would take a good deal of time, as everyone is quick to point out. What's the point of doing this? We'll have guns, that will last forever. So this is only going to be a partial solution at best. But I think there are a number of opportunities were the agency, the FDA, to get its device hooks into the firearms industry, that it could push things in a more positive or productive direction.
Yeah, that makes a lot of sense. It's been a really fascinating discussion. Really appreciate you joining. Thanks to all of you at home for watching another episode of the Scholarship Highlight series. Please check us out online at firearmslaw.duke.edu. And thanks again to Professor Noah for joining us.
Thank you for having me.